Hey, Nate Webb at Seattle DUI Pros here to talk to you about refusing a breath test in a DUI case. Is that a good idea? Should I do it? Shouldn't I do it? What have you? So, here, let's talk about it. A breath test refusal can be used against you in an administrative hearing or in a criminal matter as well to enhance penalties. So, whenever you got a driver's license here in Washington, there was an implied consent that you would take a breath test if you were ever charged with DUI or arrested for DUI, meaning that if you didn't, there would be certain sanctions the Department of Licensing could take with respect to your driving privilege. If you refuse a breath test in Washington State and there's an administrative hearing and there's a finding that you in fact violated that, then you would lose your license for at least 1 year. It could be up to 2 years if you're actually convicted in criminal court of a DUI refusal. So a lot of times people are asked, should I do it or shouldn't I do it? Well, there's two trains of thought on that. One is that if you don't do it, hey, maybe they don't have enough information to convict you. But in all likelihood, they'll probably go and get a warrant for your blood, and so you're really kind of facing that situation, even though your blood might come back and it's .081. You're still facing the allegation of refusing. And so the best bet, the best train of thought, in my opinion, is to go ahead and take that test, and then you can challenge it through the accuracy and reliability of the results at a trial, or perhaps maybe there was some procedural error or technicality or something like that which might keep it from coming in. Of course, if you refuse, there's going to be an implication, intimation that you did it because you knew that you would blow over the legal limit, what we would refer to as a consciousness of guilt. And so a lot of people ask me, hey, should I take it or not? So that's my advice. I think that it's in all likelihood to your benefit to go ahead and take it. Not only does it show that you're not trying to hide anything, you may never tell. It could actually be lower than you might think it might be. And so it's better to go ahead and cooperate and not put yourself in a position where you've got to fight it. Although I've had lots of cases where the jury understood that, hey, that my client didn't trust the machine or had been told, advised by someone before, an attorney, for example, not to do it. And that's a valuable and logical argument a lot of times. And I also argue if they don't get the blood, then hey, you could have got the blood and we wouldn't be sitting here having this conversation, and you would have more evidence if you just followed through and got a warrant to get the blood. So refusal is probably not your best course of action because it does have an impact on your driver's license, especially if you have a CDL. And so it's definitely to your benefit if you're a CDL holder to go ahead and take a breath test. And so there are a couple of breath tests used in Washington State, breath test machines, the Data Master and the Draeger, and I'll talk about those more in another video. But hey, if you or anyone you know has been arrested for DUI and looking to hire fantastic attorneys here at the Webb Law Firm, call us up at 425-522-4200 or visit our website at seattleduipros.com or WebbAttorney, W-E-B-B, attorney.com. Thanks. One thing I forgot to mention in the previous video, so I've added on here at the end, is that a lot of people are told there at the station by the officer that if you don't take this test, if you refuse this breath test, you're going to lose your license for a year right away. That's not true. It doesn't happen immediately. You have a continued privilege to drive. You have an opportunity to challenge any suspension of your license by filing what's called a DUI hearing request. And so you'd have 20 days from the date of the arrest to ask for an administrative hearing, which is conducted by telephone, to challenge any suspension of your license. So it's not an immediate license suspension. So if you were told that by law enforcement or even another attorney, that's incorrect information. It doesn't happen right away. There's a process for it. There's an administrative hearing that you can ask for. Of course, if you do not ask for the hearing, your license will be suspended, but it will take 60 days from the date of the arrest. They won't take action on it for 60 days, and so it's not an immediate suspension. So I just wanted to add that little piece of information on there for you to consider when you're looking for an attorney to help you with a case like this. Again, 425-522-4200.